Unfortunately, it's going to be several years before this actually starts to take effect. But I think it is really important for organizations to start preparing for these reporting requirements and make sure that they're in a position to comply with the law when it gets passed.
Hello, everyone, and welcome to Caveat, the CyberWire's privacy surveillance law and policy podcast. I'm Dave Bittner, and joining me is my co-host Ben Yellen. He's from the University of Maryland Center for Health and Homeland Security. Hello, Ben.
Hello, Dave.
Today, Ben has an update on the Texas social media platform case. I've got the story of Canadian ISPs being ordered to block pirated streams of, wait for it, hockey games. And later in the show, my conversation with Greg Murphy. He's from a company called Order. We're discussing the Strengthening American Cybersecurity Act. While this show covers legal topics and Ben is a lawyer, the views expressed do not constitute legal advice. For official legal advice on any of the topics we cover, please contact your attorney. And now, a few thoughts from our sponsors at Microsoft Federal. The U.S. government is partnering with industry professionals to fortify their cybersecurity posture in compliance with the new executive order on cybersecurity. Microsoft Federal is here to help. They empower federal agencies to meet key executive order milestones with free resources like their Zero Trust Reference Architecture and Cloud Adoption Framework. Learn how you can accelerate your cyber journey today by optimizing existing technologies and implementing new ones. Empower people, enhance government services, improve national security. Learn more at aka.ms/cyberEO. That's aka.ms/cyberEO. All right, Ben, let's jump into some stories here. Why don't you kick things off for us?
So just after we finished recording our previous episode, we got a Supreme Court decision of sorts on their so-called shadow docket. So this is when they issue a decision that hasn't been presented to them via oral argument. They're just making a snap decision based on a petition from the parties. And this has to do with the Texas social media platform statute that we've talked about several times on this podcast. So as a quick refresher, the statute prohibits viewpoint discrimination on social media platforms that meet a certain threshold. So they have to have 50 million users. They can't be your mom and pop social media companies. They have to be the big guys. Once they are established as big social media platforms, they have certain reporting requirements related to how they make decisions about banning certain users and this viewpoint discrimination provision, meaning...
This is the origin of this is the folks on the Republican side making the case that they believe that their points of view are being censored by the big platforms.
Exactly.
It's in response to that belief.
Exactly.
Okay.
And so we've seen this pop up in a number of states. Another one where this was enacted was Florida, and there was a similar court case there. What happened in Texas is everybody sort of assumed that this law was going to get struck down immediately. The platforms themselves have First Amendment rights, and if you were to take the enforcement provisions literally in the statute, the tech platforms would be forced to publish viewpoints that they do not want represented on their platform.
Such as
certain types of things that we would define as hate speech.
Okay.
If the state of Texas defined that as viewpoint discrimination and forced the social media platforms to put that content on in public on the platforms, then that would violate the First Amendment speech rights of these companies. And there has been previous case laws saying to an effect that you can't compel somebody to be a platform for speech, a private organization to be a platform for speech for which they vehemently disagree with that speech.
Yeah. And this to me seems like a textbook First Amendment case where we're protecting a private organization from the government.
From the government, exactly.
Right, okay.
If you recall, the beginning of the First Amendment says Congress shall make no law.
Right.
That's been incorporated to the states through the 14th Amendment.
Okay.
Which means that it also means the Texas legislature shall make no law abridging the rights of freedom of speech.
I see.
But they sort of did.
Yeah.
The district court, so the trial court level, at the federal level, weighed in and issued an injunction against the law. Unexpectedly, the Fifth Circuit Court of Appeals, which has a very conservative membership, vacated that injunction, meaning the law was put back in place.
Right.
That
was the one they did without comment, right?
No comment.
They just did it.
And it's been about 6 or 7 weeks now, and we still don't have their justification for why they vacated that injunction.
Huh.
But they did. The law was put back in place. So the companies petitioned to the U.S. Supreme Court to stay the ruling of the appeals court, if that makes sense, and enjoin the law again from being enforced.
Okay.
So take the law once again out of commission.
Right.
We were looking for guidance from the Supreme Court because we had now seen conflicting case law in different jurisdictions. So we had talked about the Florida case where a court came out one way, and then there was the Fifth Circuit Court of Appeals, which came out the other way. So we were looking for guidance from the Supreme Court, and we got it, sort of. So by a 5-4 vote, the Supreme Court did vacate that stay and issued an injunction against the enforcement of that law. So the law is currently not in place, once again, in the state of Texas, pending further legal proceedings.
Okay.
The majority was silent. They gave no reasoning for their decision. They don't have to. It goes back down to the Fifth Circuit Court of Appeals, who will now have to hear the district court case on the merits. So they're going to have to consider, through oral arguments, the competing interests of both sides. The 5 justices in the majority, you have two of the liberal justices, so Justice Breyer and Justice Sotomayor, and then 3 of the more conservative justices, Chief Justice Roberts, Justice Kavanaugh, and Justice Barrett. Then we have the dissenters. The first 3 dissenters did not surprise me at all. This was a joint dissent, about a 6-page opinion written by Justices Alito, Thomas, and Gorsuch.
Okay.
And they weighed in on the merits, basically saying that they thought the state of Texas had a good chance of succeeding in this case if the case were heard in front of oral arguments. Their justification is that in this day and age, it's unclear whether social media companies should be seen as common carriers, in which case governments, whether that be the federal government or state governments, would have some role in regulating what these social media companies do. If these social media companies have an extremely large market share, to the extent that there aren't viable alternatives, then the government, based on past case law, can I guess, offer a level of control over these companies vis-a-vis constitutional rights, as if they were common carriers, like Amtrak or a utility company that had a large market share in a local market, for example.
Like the phone company also.
Exactly.
Common carrier example, yeah.
So you have 3 justices here pretty much endorsing that view. Now, they didn't say it explicitly. What they were saying was it's very plausible that that view could prevail. We might as well keep this law in place while there are further proceedings. The Court of Appeals and the Fifth Circuit can go through the full process of hearing the 2 parties, coming to a decision. If that decision is appealed to us, we can go through our full process. But at least it's plausible and, in fact, somewhat likely that the First Amendment rights of these companies have not been violated as a result of this Texas law.
Okay.
So those were the 3 conservative dissenters. The 4th dissenter, which was a bit of a shock, was Justice Kagan, who was considered a more liberal justice. She was appointed by President Obama. She, much to my frustration, the frustration of many observers, did not say why she was dissenting. She did not have to say why she was dissenting. This is an injunction, so it's not a full opinion. She certainly was well within her rights to not declare why she was dissenting. She has expressed disdain in the past for major policy decisions being made through the shadow docket, so that could have been a justification for her dissenting here, but we just don't know. And the reason that's somewhat worrisome to observers, the tech companies, and frankly, people who want to protect the First Amendment rights of these platforms to moderate content as they see fit, is you are 1 justice away now, potentially, from upholding a pretty radical law like the one that Texas proposed and enacted. We have 3 justices who seem to be amenable to the law on the merits, and we have 1 other justice that, for whatever reason, didn't want to issue an injunction against the law being enforced. So that's at least a hint that in the future, these companies really might be subject to regulation based on how they moderate content, and there really might be a viable case down the line about so-called political bias of big tech platforms where a state can step in and issue sanctions to Twitter or Meta or whatever for what they see as viewpoint discrimination. Now, as we've talked about, that's going to be very difficult to enforce.
Right.
We have no idea how that would work in practice, if it could work in practice. What we saw from this Supreme Court case is that we should probably start to at least consider those questions, frankly.
Where does this go next?
So it goes back to the Fifth Circuit Court of Appeals. They are going to hear the case on the merits and presumably issue a holding on the merits. So they're going to actually have to, unlike their previous ruling, go through their reasoning, a constitutional analysis of why the Texas law, in their view, is or is not constitutional. That could potentially be a very long process. Depending on the outcome of that case, if the Fifth Circuit, as I would expect, sides with the state of Texas, then the big tech platforms will petition the Supreme Court to issue a writ of certiorari and hear the case in one of their next terms, whether that's the 2023 term, which starts in October, or the 2024 term, which starts the next October. And we'll have at least one new member of the court, since Justice-to-be Ketanji Brown Jackson will have joined at that point. So all this means for now is that the law is not in effect while the proceedings continue. Based on what we know about the Fifth Circuit, it seems as if there's at least a strong chance that they would put the law back into place. They would vacate the initial injunction once again of the district court. And then who knows what would happen if there were a full argument at the Supreme Court. Perhaps the three dissenting conservative justices would be able to, through the process of briefs from outside observers or constitutional scholars, may be persuaded to consider big tech platforms as common carriers. And that would just have vast, wide-reaching implications across a bunch of different spheres.
Yeah, that's huge. I mean, are you and other observers surprised that this Supreme Court ruling was as close as it was?
Yes. Now, again, I have no idea what Justice Kagan was thinking. I want to just go up there and be like, please, just give me one sentence. You can use cryptography, maybe only write it so that I can understand it.
Is she not returning your phone calls, Ben?
Yeah, or put it in secret code, maybe make an acronym that gives me some hint as to what she's thinking. I mean, my guess is it's a procedural objection and that she is not actually a fourth vote for this common carrier view, but I don't know. So it certainly did surprise me that it was a 5-4 decision. Justice Thomas had previously indicated an interest in regulating big tech platforms as common carriers. Justice Alito usually sees eye to eye with Justice Thomas on this. Justice Alito has spoken contemporaneously in many documents about his disdain for what he sees as big tech political bias. He's just a conservative-oriented individual, and I'm not surprised that that's his viewpoint.
Yeah.
Not surprised to see it from Justice Gorsuch as well. I think he sees eye to eye on these issues, just like Justice Thomas and Justice Alito. So Kagan was the surprise for me.
Yeah.
I have no idea what the broader implications of that might be. But if for some reason she did agree with Justice Thomas on the merits, then you'd only need to pull off one more justice. And certainly, I think Justices Kavanaugh and Barrett, given their political disposition, would at least potentially be amenable to that argument. So it's something we really have to be watchful for. And I think, as we mentioned previous times, this is not just going to happen in Texas and Florida. There are a lot of states with Republican state legislatures who strongly dislike big tech platforms and think that these platforms are biased against conservatives. And we're going to see these types of laws enacted in a number of different states. And I think until we get some sort of definitive resolution on this, which we don't have at this point, that's going to be an open question.
Yeah, boy, it's going to be fascinating to see this one play out, because it's like flipping the table upside down. If you make them common carriers, that's a big change.
It's an enormous change. And it's not just in this area of the law. I mean, there are tons of regulations governments can issue on common carriers, even for things like common law torts, that would make life a living HE double hockey sticks. To give you a vague preview of our next story.
Right.
So the tech platforms would freak out, basically, if they were put under the microscope like that. So they're going to hire the best appellate attorneys in the country to make sure that doesn't happen.
Right. All right. Well, we'll have a link to that story in our show notes. My story this week, I originally came to me over Twitter. There's a gentleman named Andy Kaplan-Mirth, who is a telecom lawyer in Ottawa, Canada. He brought this story to my attention. And then I found a write-up about what's going on here on the website Torrent Freak. The title of the article is NHL Broadcasters Win Canada's First Dynamic Pirate IPTV Blocking Order. Basically, what's going on here is that the rights holders to hockey games in Canada, the broadcasters who have spent a lot of money for those rights, have convinced the Canadian Supreme Court, and correct me if I'm wrong here, Ben, the Canadian Supreme Court, that Canadian ISPs have to do dynamic blocking of particular IP addresses while hockey games are being broadcast in order to block pirated streams of those hockey games.
That's right. Now, first, I will say I'm thrilled to be talking about the NHL on this podcast. Never thought I'd have the opportunity. I'm a big hockey fan myself. I'm wondering if I can get your prediction on the Tampa Bay Lightning versus the Colorado Avalanche in the Stanley Cup Finals.
Okay.
Yeah, throw a dart at the wall.
I think the best team will win, Ben.
There you go.
Yeah.
I like that prediction.
Yeah.
I don't think you can understand the story without understanding how important hockey is in Canada.
Right.
I have some Canadian ancestry, and it is life or death there. Think about this like the rights to broadcasting the Super Bowl. Hockey gets such incredible ratings in Canada that they've measured the impact on sewage systems during major hockey games. And you'll see that during the first and second intermission of a hockey game, a lot of people are flushing their toilets.
Yeah.
And it has a measurable impact.
Okay.
Because people are sitting through the actual hockey action.
Yeah.
So the rights are extremely valuable there. If people are able, through piracy, to watch these games or to stream these games illegally on platforms, that's an enormous portion of the revenue of some of these big media companies. So the big media companies in Canada, Rogers, TSN, ITV, I believe, is another one. They pay an arm and a leg for these rights.
Yeah.
And the government is basically protecting their intellectual property, their ability to have exclusive broadcasting rights for these mega events by having this dynamic way of shutting down online piracy.
Right. So I'm speaking hypothetically here, but I think this description would hold up. So say, for example, the Stanley Cup were being broadcast in the U.S., where hockey is popular, but certainly not as popular as it is in Canada. Someone living in Canada, rather than paying for their local stream, could latch on to a U.S. stream where perhaps it's streaming for free because it's not as in demand, and then they avoid having to pay for it locally.
Yeah, some people, I'm not going to name them, might use VPNs to illegally stream sporting events. I'm not sure how street legal that is, but you can certainly, through a VPN, place yourself in a U.S. market, buy an ESPN Plus subscription if you want to spend a minimal amount of money, and can get that broadcast for free without having to pay the exorbitant fees for a full cable package in Canada, which I'm sure many Canadians only get that cable package to make sure that they can watch the Stanley Cup, or the Stanley Cup playoffs, rather.
Yeah. So help me understand here. This article points out that the federal court grants an interlocutory injunction. What does that mean?
It means...
Lawyer boy.
So an interlocutory appeal means it is an interim, non-final decision where they are granting some type of injunction, as they are here, against the actions of the defendants who are unnamed individuals who have pirated hockey games.
I see.
Without completed proceedings at the court. So it's an appeal without having gone through. It's a judicial decision without having gone through the full and complete process that one normally goes through to get a decision at the Canadian Supreme Court. Now, I am not an expert on the Canadian Supreme Court.
Oh, come on, Ben.
I know it's a little bit less powerful than our Supreme Court.
Okay.
I don't know if they have the same level of judicial review powers that we do. I think their legislature, the Canadian Parliament, is more powerful than our Congress, for example.
Yeah.
But there's a reason they're stepping in now, which is because we are in crunch time in the Stanley Cup playoffs, and there is a lot of money to be made and lost over the next several weeks as these playoffs continue. I mean, that is prime rating season.
Right.
The companies don't want to lose that revenue because they're not going to have an opportunity to gain that revenue again. Granted, the contracts have been signed.
Yeah.
But they're not going to have the same viewership until this time next year. So the interlocutory appeal is designed to expedite that process so that these companies can get some level of relief during this pretty valuable time period.
Right. So they've got some oversight here. As you mentioned, this ruling or this order expires after the Stanley Cup ends. They're requiring some third-party auditing to see if it actually works or not. Some of the ISPs have to get paid for their efforts in doing this.
Right, and it's no small effort on the part of the ISPs. I mean, it takes a lot of compliance work on their part.
Let's look at the big picture here, though. There are some civil liberties folks who are concerned that, as always, that this could be a slippery slope.
How so?
Well, just that the broadcasters aren't going to stop here. That if they ask for this, they're going to ask for this for obviously all hockey games.
Right.
But then what else? And what else gets blocked? And what gets caught up in the blocks? And, they're saying we need to be mindful that the court just doesn't give the broadcasters a blank check for what they want to have, for what on the internet, right? They're not their domain to be blocked.
Right. I would say I'm usually amenable to those types of slippery slope arguments, but knowing what I know about hockey in Canada, this is the slippery slope. If you are enforcing a ruling during the Stanley Cup Finals, that is as far as you are going to go.
Oh, Ben.
Nothing else matters.
I think you're being clouded by your love for hockey, Ben. I think
I am, but I also believe that. I mean, how much further can you go if you are a Canadian broadcasting company?
Right.
I mean, curtailing people's ability to watch curling or sled dog racing does not have the same effect.
Yeah.
This is serious business. Covering the Canadian elections or, the provincial news in Ontario, I don't think carries the same cachet in Canada as a single game in the Stanley Cup playoffs.
Okay.
And I think I'm not just saying that as a hockey fan. I think I'm saying that as somebody who understands the basics about Canadian culture.
Yeah.
So I'm sympathetic to the slippery slope argument, but I don't think that's really applicable here. I mean, I think the fact that they were willing to do this for the Stanley Cup means that they take the anti-piracy rights of these broadcasters very seriously.
Yeah.
I think that is the best indication that you're going to get.
Okay. All right. Fair enough. Well, we will have a link to that story in the show notes. We would love to hear from you. If you have something you'd like for us to discuss on the show, you can email us. It's caveat@thecyberwire.com. So let's return to our sponsor, Microsoft Federal. Microsoft Federal is answering the nation's call on cyber with a strategic roadmap to help federal agencies meet key milestones of the Cybersecurity Executive Order. They work to guide agencies in three main ways. First, they empower agencies to address sophisticated cyber attacks efficiently and effectively with a series of zero-trust reference architectures. Second, they offer a phased rollout plan to ensure federal agencies are meeting cyber requirements. And third, they provide direct engineering resources to help agencies implement the tools that they already own. Microsoft Federal is ready to do their part to modernize the government's IT infrastructure and strengthen the nation against future cyber attacks. Learn more at aka.ms/cyberEO. That's aka.ms/cyberEO. Ben, I recently had the pleasure of speaking with Greg Murphy. He's from a company called Order, and our conversation centers on the Strengthening American Cybersecurity Act. Here's my conversation with Greg Murphy.
Sure. I think this act was pulling actually from three other pieces of legislation. And what it's really designed to do is to ensure that entities and organizations in critical infrastructure segments have a responsibility to report cyber incidents very promptly within 72 hours after an incident occurs, or in the case of ransomware, where someone's paying a ransom to bad actors, to report that within 24 hours of making that payment. And so the intent here is to ensure that information is being shared and disseminated widely so that other organizations and other entities get the benefits of understanding what is happening, how organizations have been responding, and can take steps to defend themselves. So the whole goal is to enable a more coordinated, faster response and ensure that people have visibility to the threat landscape as quickly as possible.
Well, this has passed the Senate and has yet to make its way through the House. So, how are we looking in terms of its prospects there?
Well, I think it looks very good. I think, when you looked at the Senate, it passed unanimously. And in this day and age, that I can't think of too many things that make it through the Senate with unanimous agreement. So I think that, especially in response to recent events in Ukraine and in world events and the concerns about cyber threats to national security, I think there is just a heightened focus on this where, a few months ago or years ago, this may not have been possible, but I think it's looking very positive and expect that it would actually make it through the House as well.
Can you share your insights on this sort of disclosure legislation? Where do you come down on this? Is this a good thing?
I think overall it's a very good thing. When a cyber incident occurs, the main thing that we want to do as an industry is ensure that everyone gets as much information as quickly as possible so that other organizations can take steps to defend themselves. Because the reality of the world we live in is that the bad actors, the criminals that are propagating this malware, they rarely go out and target just one organization. They're going after multiple organizations. Very often they're deploying malware and it's sitting dormant on network for months or even years before it's activated. So the assumption is that whenever one organization is subject to attack, there are probably lots of others that are in the sights of these attackers, and getting information in people's hands as fast as possible so they can take proactive steps to protect themselves and to protect their businesses, to protect consumers, to protect patients in healthcare. That's all very beneficial. So I think this is a big step forward. I think it's been a long time coming. Unfortunately, it's going to be several years before this actually starts to take effect. But I think it is really important for organizations to start preparing for these reporting requirements and make sure that they're in a position to comply with the law when it gets passed.
What about the actual requirements themselves? We're talking about 72 hours here for reporting cyber attacks and 24 hours for ransomware. I've heard some folks say that perhaps that puts an undue burden on the organizations. What are your thoughts there?
I think it really comes down to, in this act, it's put CISA, the agency, in charge of defining some of the specific regulations about what exactly needs to be disclosed and when. But I think you're right. I think it has to be the regulation has to balance the need for information to be shared quickly with the reality that when you're 70 towers into a cyber attack and you're the CISO of the organization, you're probably in absolute firefighting mode. You don't always have perfect or complete information. And so I think the regulations need to reflect that and understand that information may be partial, that information may change over time and need to be updated. And I think they also need to make sure that as they think about these regulations, they recognize the differences between types of organizations and the resources that they have available to them. In healthcare, which is one of the critical infrastructure categories, you've got everything from small community hospitals that may have one or two people in the IT organization in its entirely, and then you've got very large multi-billion-dollar organizations with immense resources available. And so the regulations need to make sure that these organizations can realistically provide that information, and also make sure that they have enough protection that they're not feeling like they are being put at significant legal or business exposure by making these disclosures. So that the goal here is information sharing and speed, and not punitive to go after and punish organizations that are victims of these attacks.
What do you suppose this is going to mean for those various sized organizations in terms of the adjustments they're going to have to make to be able to comply?
Well, I think one of the things that are really important is that organizations start to prepare, if they haven't already done that, to make sure they have good monitoring tools in place so that they know what devices are connected to their network and what those devices are doing. And so when malware comes into their environment, that they can identify where it came from and how it may have spread, and what protocols it used on the network. There are tools like ones, frankly, that we develop on the market that enable them to do that. And it's important that they have those types of systems in place, because certainly when you're in the midst of an attack, that's not the time that you're going to be able to go and put in new systems and processes. So when you're firefighting, you don't want to be having to spend your time trying to gather data and figure out what you're going to need to pull together in order to meet the reporting requirements. You want to have those systems and tools already in place, so that you have them at your fingertips and frankly can use them to help you respond more quickly and in a more effective manner to any attacks that occur. So I think this is the good news here is that CISOs have been thinking about this for quite a while, and this is really, I think, an instigator for them and for their organizations to make sure that they have the appropriate infrastructure in place to enable them to comply with this regulation.
This act is all about disclosure. What about what comes next? Do you envision us getting to a point where we're actually doing information sharing?
Yeah, that's to me the critical part. It's the whole goal of this has to be information sharing. I mean, just disclosing the information may help the government in compiling statistics, but the goal of having the disclosures happen so quickly is presumably so that information can be shared very quickly with others. And you see that all the time, is that we have bad actors and criminal gangs that are attacking multiple organizations, and so having that visibility from what's happening in another organization and getting information about what the indicators of compromise are, how the malware was spread, what was done to defend against it, that's incredibly valuable information. So if there is no sharing, then there's no point to this legislation, really.
So what's your advice, for organizations who see this coming along and want to be prepared for when it actually goes into effect? What sort of steps should they be taking now?
Well, I think the first is make sure that you have basic hygiene in place. If you think about yourself as an organization, you need to know what devices are connected to your network. What those devices are, how they behave. Have the ability to detect anomalous behavior very quickly. For example, if you see a video surveillance camera on your network that is suddenly talking to your financial systems in a way that no video surveillance camera has ever done before, you want to be able to know about that, flag it, and take action immediately. those types of systems, having that in place will enable you to quickly provide the type of information that the government's going to be looking for, after these responses, to be able to, or after these incidents, and be able to share that information very effectively with other organizations. So I would really look to putting that basic hygiene in place. Make sure you understand exactly what's connected to your network, what those devices do, and have anomaly detection capabilities in place.
All right, Ben, what do you think?
Wow, Congress is actually doing something. I'm as shocked as you and Mr. Murphy were in your interview. I think the prospects, as he said, are quite good for this legislation. Again, it's largely a legislation geared around reporting. That's usually the first step and not the last step. A lot of it is going to depend on how it's enforced by CISA.
Yeah.
But it has passed the Senate. That's usually the hardest hurdle.
Right.
Because there are all these procedural things you can do in the Senate to come up the works. And the fact that you had unanimous support, I think, is a very positive sign.
Mm-hmm.
I don't think it would have happened several years ago. I think it's happening because we've all now been impacted by cyber attacks, ransomware attacks that have had these kinetic effects where it's not just affecting people in the industry, it's affecting the everyday Americans who call their members of Congress.
Right.
I think the prospects are good in the House. So I think there's a strong chance that this could be enacted into law. And it's just fascinating to hear about what the impetus was for this law, how the federal government was able to put something together to at least begin to try to respond to this problem.
Yeah.
And it's really about having situational awareness on what the threats are.
Right.
Reporting itself isn't necessarily going to change anything overnight, but it's about giving other entities who have not yet been subject to these attacks the awareness of the threat landscape. And I think without these types of reporting requirements, a lot of private and public organizations are largely in the dark. So I think this holds a lot of promise.
All right. Well, our thanks to Greg Murphy for joining us. We do appreciate him taking the time. And of course, we want to thank this week's sponsor, Microsoft Federal. With a rich repository of cybersecurity implementation guidelines and best practices, Microsoft is your partner in achieving the cybersecurity milestones. Learn more at aka.ms/cybereo. That's aka.ms/cybereo. And that is our show. We want to thank all of you for listening. The Caveat podcast is proudly produced in Maryland at the startup studios of Data Tribe, where they're co-building the next generation of cybersecurity teams and technologies. Our senior producer is Jennifer Iben. Our executive editor is Peter Kilpe. I'm Dave Bittner.
And I'm Ben Yellen.
Thanks for listening.